Okay, so we have torts. We just finished talking about unforeseen consequences, and now we're going to get into intervening causes. And the thing to note here is that intervening causes and unforeseen consequences are so closely interwoven and that it can be a little difficult sometimes to see the difference between the two. What an intervening cause is when a third party comes in and does something that may interrupt the pattern of causation. So, let's just look at this from a timeline standpoint. We have a party who is negligent. Let's just look at, for example, the oil spill that we talked about in Wagamon cases. Party that was negligent in pouring oil into the water. So that happens. After that, a molten wire falls onto a cotton ball, which catches fire and causes the fire all around, which ultimately causes damage to the plaintiff. So you can see that there's three steps here. You have the negligent action, you have what could possibly be considered a trigger or an intervening cause, and then you have the damage that results from that. So there's these three steps here, and that second step may be considered the intervening cause. I also want to note the difference between an intervening cause and a superseding cause. A superseding cause is actually a type of an intervening cause where the result is so unforeseeable that it's actually going to break the causation that holds the defendant liable. So, for example, actually, we'll do a couple of cases later to give an example. Ultimately, what a superseding cause is something that is just so unforeseeable and that we won't hold the defendant liable anymore because there was this third-party thing that breaks that chain of causation. They came in, they stepped in it, they took an axe to the chain, and it snapped, and now if you're to sue somebody, it's going to be that person who had the superseding cause. Whereas if it's only a mere intervening cause, well, then you can still hold the defendant liable for those cases. So we have a couple of cases here. I won't try and pronounce the name of this first one because I can't do it. But the defendant in this case is going to be Felix Contracting Corporation. And what happened here is that it was a workplace car accident. The plaintiff was working on a pipe. He had some sealant. It was hot. It was boiling. And a car driver had an accident, had a seizure in the middle of their driving, which ultimately caused them to swerve off the road into the workplace area. It hit the person. It hit the stuff that he was using to seal the piping, and it caused a whole lot of damage. The person's very lucky to be alive. And so he sues the general contractor. So the defendant here was working for a subcontractor. The plaintiff was working for the subcontractor, and he sued the general contractor, which is Felix Contracting Corporation. And what he is arguing here is that the defendant, the contractor, should have put up barriers that would have prevented such a workplace accident. And you're going to notice here that we're going to do a very similar risk analysis that we had done for unforeseen consequences. Why? It's because we need to look, why should he have put up the barriers? What was the action that you were trying to avoid? Why is it negligent to not put up those barriers? And it's because the car could come swerving into the area and could cause an injury. And the defendant here is arguing, saying, wait, hold up. We're not liable for this because the driver had a seizure. We couldn't have seen the driver having a seizure. We couldn't have seen him driving his car into the area due to that seizure. There's no way we can be held liable for this because, well, we didn't actually cause the accident. But the court says, no, you can be liable here because what was the foreseen consequence that you were trying to avoid? And that was to have a vehicle drive into the area that could potentially cause harm or damage. It doesn't matter how the vehicle got there, the consequences that brought it there, as long as it was foreseen enough to get the vehicle there. And so that's Felix Contracting Corporation. We have two more cases here that I want to talk about just briefly, really to emphasize this point of a superseding cause or an intervening cause. We have Watson versus Kentucky and Indiana Bridge Railroad Company. What happened here is that a train had become derailed. Gasoline had spilled all over the place. And a third party here lit a match. And here's where things are split. One testimony says he lit a match just to light a cigarette, and he tossed it on the ground after lighting the match, and before the match hit the ground, the gas fumes exploded, causing a fire which injured the plaintiff. The other possible testimony that had happened, that witnesses had heard, is that he ran towards the train saying, "I'm going to light this place on fire." And he lit the match, and he threw it on the ground, intending to light the fire. Why does this matter, the conflicting testimony? Why do we need to figure out which is actually the true statement? It's because we're trying to figure out whether or not his actions were a superseding cause. If his actions were innocent, or even if they were negligent, and sometimes if it's reckless, it's not going to be considered a superseding cause. However, if his actions are sometimes reckless, but all the time malicious or intentional or even criminal, well, then that can be seen as a superseding cause. So, if he just lit a match to smoke a cigarette and then threw the match on the ground and caused the fire, that might be negligent. It might even be innocent. And the defendant, the railroad company, can still be liable for their negligent action of spilling the oil, the gasoline. On the other hand, if he ran towards the place, lit it, and intentionally lit it on fire, you can't say that the defendant is liable for that anymore, because it's unforeseen that somebody would just act maliciously to cause the fire. And so it all comes down to which testimony the jury believes in this case, whether or not it was negligent or innocent of this third party or malicious of the third party. And once again, we're going to be doing this through a risk analysis standpoint. What was the injury that you're trying to avoid? And you're trying to avoid a fire. And how are you trying to avoid it? Well, you should be trying to clean it up. But there's no way to stop somebody who's malicious in their intent to start a fire. And so that's why it can be considered a superseding cause. Finally, on a more kind of sad note, we have Fuller versus Priest, and this is a suicide case. The thing to note is that most of the time, suicide is going to be considered a superseding cause, meaning a person is not going to be liable for their actions causing injuries to the point where a person commits suicide. Suicide, most of the time, is going to be considered superseding. However, in Fuller, we have an instance where it wasn't considered superseding. And what the test here that Fuller applies is that if the injury causes an irresistible impulse of suicide, then the defendant can still be liable. And that's just saying that there's pretty much no breaking causation. What is an irresistible impulse, and how is it different? How can that be broken? Or rather, how can you prove that there was not an irresistible impulse? Well, an irresistible impulse can be shown, or rather it can be shown that there is no irresistible impulse if there's some planning that goes into the suicide. Whether the person leaves a note, it takes the time to go out, buy a gun, buy a shell or cartridge that can be fired in the way to cause injury. And if that's the case, then you can't say that there's an irresistible impulse. So, in Fuller, we just learned that there's an irresistible impulse test that some of the jurisdictions apply. Most of the time, suicide is going to be considered superseding, but some jurisdictions use this irresistible impulse where you need to show that he had no control over the impulse, just subject to it. And if you can't show that, the defendant needs to show that they did have control over it, and in fact it was planned. And all of that is going to be shown to a jury to determine whether or not the defendant can be liable for the suicide that occurred due to injuries that happened from a previous incident. And that is finishing. Actually, it doesn't finish. We have a couple more cases of intervening causes that we'll get to next week. And then next week, we'll also finish proximate cause. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.